Good morning to everybody. My name is Ian O'Herlihy and I'm head of the education department in Mason, Hayes and Curran. A very big welcome to you all and a particular welcome to anybody who's joining our webinars for the first time. Today's webinar is, I think, the 10th webinar that we've put on since last summer. And if any of you are interested in accessing our previous webinars, we'll mention at the end of this session how you can do that. I suppose really this morning, given the incredibly challenging stop-start experience that all of you principals, school leaders have gone through over the last 9 or 10 months, I should really empathize with you all for the incredible difficulty that you've experienced with your schools. As recently as yesterday and the day before, we all know what's gone on, even just in relation to the special schools, which has been really upsetting for a large number of people. And I mean, really what we're saying to ourselves on the education team is what I would say to you, and that is, hang in there. Things will get better as they will, and hopefully we will all try to be able to return to something approaching normality. I think it's also important to acknowledge, as I think the entire country does, the amazing job that you principals and school leaders have done in this pandemic. So our webinar today is why data protection affects the way secondary schools operate. And I just want to say at the outset that this webinar isn't even going to attempt to cover the entire gambit of data protection for secondary schools. We'd need a full day to do that. But what we are trying to do is maybe to look at the general principles of data protection, GDPR, and how they affect schools on a day-to-day basis. And we're going to try to share with you some of the particular maybe cases that come in our door, case studies, if you like, to see what we can all learn from those in terms of trying to avoid pitfalls down the way. Can I introduce my colleagues on the today's webinar, my partner Liam Reardon, Catherine Kelly, David Ruddy, and Paul Byrne of NAPD. And can I just thank Paul for and NAPD for the support in the promoting today's webinar. Paul has done such a good job that I think we have 350 registrants on today's webinar from the secondary sector, which is fantastic. And as a result of the large number of registrants, the chat function we've had to turn off because it wouldn't be possible with the large numbers. But what we have done is we've got a lot of questions in from schools, and we've tried to incorporate those into our webinar today. So here's a little overview of kind of some of the stuff we're going to look at. We've called personal data the new oil, and we'll try to explain that as we go along. We are looking at the law, a data protection law, and we do that unapologetically because we're lawyers and we deal with legal issues, hopefully in a practical way. We're looking at who is the data controller in your school. We're looking particularly at data breaches. We're looking at data management and retention. We're looking at data access requests, or DARs as we call them. We have some case studies. A word just throughout this webinar, you'll hear us repeated is, check your policy, update your policy, discuss it with your staff. What is the law? Well, you'll hear people talking about GDPR, the General Data Protection Regulation. It's an EU-wide regulation. It has been incorporated into Irish law by the Data Protection Act 2018. I mean, a word about the UK and Brexit. Strictly speaking, from a legal perspective, the UK is outside GDPR But just like Ireland, it has previously introduced and incorporated GDPR into its legislation. So for the moment, the UK is adhering to the principles of GDPR. And I want to just mention at the outset the 7 principles of GDPR, and I have them up there on the screen. And I'm not going to go through these individually at this stage, but you're going to hear mention of them throughout this webinar. And the reason I'm putting them up there is because lots of schools, when we're dealing with a data protection issue, we give advice that they should do X or do Y or whatever. And a lot of schools have said to us, where's that advice coming from? And in reality, the advice that we give, anybody would give in relation to data protection, emanates from one or sometimes more than one of those principles. So that's where they're coming from. That's the background to a lot of the advice that you will get. David.
Thank you, Ian, and good morning to all our participants this morning. I'd like to alert you to a new publication by the Data Protection Commission, which they published actually in December, and it's entitled Children Front and Centre. And it comes up with 14 core fundamentals or rights they feel that students should have when they're interacting with particularly online companies, but there may be also implications for schools. And the whole idea is to afford young people higher standards of protection, and that there is a right of students to access personal data and to give or not to give consent independent of the parents. So because this may have implications for schools, and it's a very lengthy document on that, the education team here in Mason, Hayes and Curran will be making a submission in advance of the closing date, which is the 31st of March. And in doing so, we'll consult with the management bodies, and I want to acknowledge that management bodies have done a lot to help schools in relation to data protection, but also we'll be consulting with the NAPD. So we will be in touch with the relevant bodies. But this could be a game changer in some sense in that, particularly at post-primary, where students would be entitled to withdraw consent in relation to the dispersal of data. And we will look at some case studies as we go along later on, which will reference this. The next piece is I'd like to welcome Liam Reardon. Liam, good morning to you.
Good morning, David. Good morning, everyone.
I have a few questions for you here. And the first thing is this Data Protection Commission. What is the modus operandi of this commission?
The Data Protection Commission, David, it's the body established to oversee the protection of data. So the answer to the question to some extent is in the title of the commission. It's established by law, and its statutory remit is to ensure protection of data in compliance with the legislation. Now, you asked about the modus operandi. Typically for schools, schools encounter the DPC for the most part when they are contacted by them in relation to a complaint that the DPC will have received, probably from a parent who has already made a data access request to the school and who, for whatever reason, isn't happy with the response received from the school. In our experience, the DPC looks to bring about an amicable resolution to complaints received. And what they tend to do is they will contact you as a school, inform you that a complaint has been received, and request that you comply with the request made by the complainant within a specified period, and that you let them know that you've done that. In some cases, that will be simple enough. It might be a simple matter to resolve, some form of oversight or whatever. but in other cases, it won't be. There will be a disagreement between the school and between the complainant in relation to the personal data held on file or whatever. And so the DPC is empowered, if an amicable resolution isn't possible, to carry out an investigation and to impose sanctions of one sort or another, including fines. Now, in our experience to date, we're not aware of the DPC having imposed any sanctions on schools in relation to alleged failures or breaches of the legislation. I know my colleague Catherine will be talking later about a case she had where the DPC did proceed to an investigation, but I'll leave that to Catherine to talk about.
Liam, it's inevitable that with over 4,000 schools in our system, 1 million students, 100,000 staff, that there will be breaches. And Ian talked about data being like oil to the system, which of course. So the Data Protection Commission has identified a number of breaches. And in fact, you have mentioned these in your own practice. You see it firsthand. Would you like to take us through some of those breaches as you?
Yeah, sure, David. Given the scale of the system, it's inevitable that that there will be breaches. We all know that oil can leak, and just looking at how does this happen typically? How do breaches come about? And we've identified two main categories: electronic disclosures, and we'll say postal, or perhaps more correctly, hard copy disclosures. Electronic disclosures can happen very simply. The incorrect recipient of an email address or a lack of consent in forwarding documentation. I recently had a case where an SNA wanted to communicate concerns she had in relation to a student in her care. She wanted to inform the principal, but she was negligent in doing that. She didn't use the school's own email system. And so she emailed the principal on the principal's own personal email address, got it wrong through a simple minor error, and ended up sending it to a third party who had no right to receive the information. And so that gave rise to quite a significant data breach involving the disclosure of somebody else's personal data. It happened accidentally, inadvertently, but it just shows how these things can happen. The non-use of BCC, again, very simple. Data accessed via compromised cloud account, easy to happen. And then loss or theft of laptops, USB keys, and so on. But I would say, despite our fixation on technology, schools shouldn't forget the possibility of there being a data breach arising from the management of documentation. I recently settled a case that was brought against a school by a parent arising from the disclosure of very personal data relating to their child in relation to alleged child abuse. And what happened was the school had kept a hard copy of allegations made by the parent, and somehow or other, that document found its way into the copybook of another student. So when homework copybooks were being returned, another student got notes that had been taken about another student. And that gave rise to litigation, to serious court proceedings, which we were quite concerned about. And fortunately, we got it settled. So it's very easy to see how these things can arise.
Thanks for sharing that, Liam. They say in life that it's 10% what happens to us and 90% how we react. So if a breach does occur, and we say that it is likely to happen at some stage, how should we deal with it?
Yeah. yeah, problems happen, and it's how you deal with them is what counts. There's a requirement to report all data breaches unless the controller can demonstrate that the breach is unlikely to result in a risk to the data subject. So you're obliged to report all data breaches unless you can demonstrate that the breach is unlikely to result in risk. Now, what we have up here is you'll remember the core principles that we posted on the first slide. The reason why the DPC requires notification of breaches is so that data controllers can comply with the principles of confidentiality and integrity and availability in relation to the control and management of personal data. So you're obliged to account for all data breaches. If the breach presents a risk to data subjects, you're required to notify the DPC within 72 hours where that's possible, or really as soon as possible after you become aware of the breach, you should notify the DPC. Where the risk to data subjects is high, those affected must be informed without undue delay. Now, even though the procedures only require you to notify the data subject where the risk is high, there's nothing in the procedures to prevent you from notifying the data subject of the breach, even if the risk isn't high. So in terms of recording breaches, you have to record the basic details of the breach, the assessment of it, and this brings us on to the next slide. And the document that's illustrated here is the DPC guidelines in relation to data breach, and it's scripture on this, if you like. And you have to have like what we've shown here is a chain of notification, which everyone should be aware of. So, typically, if a teacher becomes aware of a data breach, the principal has to be informed. There has to be an investigation and an assessment carried out of the risk, the nature of the risk posed by that breach. The board has to be informed. A decision has to be taken based on the assessment of risk, and a decision taken to report the breach to the Data Protection Commissioner. It's a very good document, the guidance note. There's a lot in it, but the core takeaways are the requirement to report unless you can show that there is no risk. You do it within 72 hours if there is a risk, and you notify the data subject of the breach if there's a high risk to the data subject.
Liam, this 72 hour, it is a huge stressor on principals when they phone the office and that. And I think Ian want to chat a little more about that.
Yeah. Timing is everything, David. You're obliged to notify the DPC within 72 hours. If you don't report within 72 hours, you have to explain why you didn't. And when you're explaining, you're on the back foot. Ian had a case that illustrates this some time ago, the importance of getting your notification as a GPC. You might like to come in here, Ian, on that particular one.
Yeah, thanks, Liam. I suppose this is just very briefly, this was a situation which I think brought home to all of our team that, two things. One is obviously timely reporting of a breach, particularly a serious breach. And the other message, I suppose, that was brought home to us was that when you do the right thing, sometimes you can just get lucky. And this was an educational institution which experienced a kind of a very serious data breach by complete human error, where they had accidentally sent out to a bunch of parents the sensitive personal data relating to a staff member, including medical assessments, medical reports, and whatever. So really probably one of the most serious breaches you could imagine. And when we heard about this, and once we got our head around it, we decided that with the institution jointly, we would immediately contact the DPC's office, which we did. And I think the DPC's office was kind of also a bit shocked at the breach and the seriousness of it. But they noted it and they thanked us for the institution for, if you like, for reporting it. Why I say things went well in so relatively after that was about 15 minutes after we had called the DPC's office, the solicitor for the staff member phoned the DPC's office because we had advised the staff member of the breach, and the staff member had contacted a solicitor. And the solicitor got on pure by coincidence and luck. The solicitor was put through to the very same individual that we had reported the breach to 15 or 20 minutes prior to that, who responded to the solicitor, yeah, you sure, I know about that. The particular institution has just been reported it. And it changed the dynamic completely, first of all, with the DPC, but secondly, to some extent, with the data subject and the data subject solicitor. Now, we still had problems. So I don't want to pretend that this was all plain sailing after that. We still had a lot of problems dealing with the data subject for a very serious breach. So just to back up what Liam said, and that is, you know, the dynamic is completely different with the DPC if you're reporting to them rather than them contacting you and telling you that they have heard about a breach and maybe asking you, you know, why haven't you reported it? So that's just a takeaway. David.
Thanks, Ian. Yeah, sorry, David.
Thanks for sharing that. Is it a case of first up, best dressed with the DPC?
I think so. I mean, just as Liam said, you don't want to be getting a call as a school or a principal saying, I hear you've had a data breach. That's not a good call to be getting.
And if you don't have all the information available to you within the 72-hour period, get what you have, the GPC, and follow up later with the rest. Don't delay until you have everything. Just act within the limit.
And that's a really important point, because often school principals want to have the whole file together when it's not possible.
Yeah. No.
Thanks for that, Liam and Ian.
Thanks, David.
Back to you. Paul, I'm going to call in Paul Byrne, Deputy Director of NAPD. Good morning, Paul.
Morning, David, and good morning to everybody.
Paul, we're going to discuss a survey that you kindly arranged with some of your members and the results. So you're going to take us through it, Paul. You did this just in the last week or so.
Yeah, following the conversation with you, David, and you wanted to get some information back in relation to the state of play, I suppose, of GDPR within schools. I sent out a survey to a focus group, and just to point out, that focus group is from, I suppose, experienced school leaders who are a number of years in the role. And we asked in relation to the schools being a subject of a data access request. 32% of the requests, as you can see, which came into those schools were from students and parents, and 14% from staff. We also asked if those that were dealing with the data requests felt confident, and 45% of them said that they were confident in dealing with the data requests. But then I suppose you have to look at the nature of the data requests too. You may be confident in dealing with some data requests, and others you may not be. And then the other question was, how many schools have been subject to a data breach? Now, within the cohort who were surveyed, 41% of those schools had been subject to a data breach.
Paul, can I just hold you there a moment? Given what our colleague Liam Reardon has said and the chart he had, Do you think that the figure actually might be higher? Because I know the survey was of school leaders, but I get the feeling that often teachers and members of staff who identify a breach mightn't actually record it or certainly inform the principal if they first of all don't understand the implications, and secondly, if they feel it's not worth reporting.
I think the figures are about right. If you think of the amount of data that schools hold, and as you pointed out yourself, nearly 1 million students across schools, 41% to me would seem to be about right, but that's within the cohort which we surveyed, and really to get, I suppose, more accurate data, we will have to survey across the full sector. I would say that that's reasonably accurate, and even looking from my own experience in schools, that would seem to be a fairly accurate assessment.
Okay, thanks, Paul, for that.
And in relation to feeling confident in dealing with the data breach, 45% of the people who responded said that they were confident in dealing with it. In relation to the data protection policies, we're delighted to see that 91% of those who responded felt that their data protection policy was fit for purpose. Now, saying that it's also, I suppose, given that you will review that data policy each year. And then we look to see where are people currently getting advice on GDPR related issues. 7% of those who came back said they were getting advice from management bodies, 9% from professional associations, 14% from others, which I assume would be legal advice. And I assume that when this webinar goes up on the system, that this will be another resource which people can go to in the event that they're looking for advice.
Paul, thanks very much for that, and we'll come back to you later on. We're now joined by Catherine Kelly. Good morning, Catherine. How are you?
Good morning.
We're going to deal with some GDPR questions, and you're going to talk about the role of the data controller, and you'll relate it to your own extensive practice in this area. So, yeah, over to you, Catherine.
In relation to the first question there, it's pretty straightforward. The data controller is the board of management, and in my experience, the correspondence that would come from the data protection commissioner would be going between the board and the data protection commissioner's office. So that's pretty simple. In relation to the level of fines and sanctions, I haven't seen a fine against a school to date. I think none of my colleagues have either. In relation to the sanctions, I had one recently where the Data Protection Commissioner investigated it and found that they hadn't given her her personal data within the 30-day period, and therefore there had been a breach. Now, there was nothing really, there was no fine, there was no real sanction, but they did say that she may be entitled to damages as a result of the breach. But that's for her to go off and get her own legal advice in relation to that breach, and she may want to bring a claim for damages against the board in that respect, but that's very much up to herself. The Data Protection Commissioner will not be taking that action on her behalf. The main issue that I'd like to deal with is in relation to pixelation, which comes up all of the time, because in relation to CCTV in schools, what we would always advise is that there is clear signage in schools in relation to the CCTV, and that you provide for it in your data protection policy. We get asked all the time, clients are asked for copies of the CCTV, where sometimes parents are looking for it, members of staff, they want a copy of whatever the CCTV is that they're looking for. I would always say that we shouldn't be furnishing a copy of the CCTV because we have no control over where it goes from there on. So we sometimes say, well, if you want to view the CCTV, you can come in and have a look at it. We would, if there are other people involved, we would ask for their consent so that they are okay with it being viewed. Pixelation, sometimes we have to do that, but it can run into the thousands, and that's an extremely heavy financial burden for any board to take on. So we would try and avoid that if at all possible.
Thanks, Catherine, for that. And moving on then to the question of data access requests, or DARs, as Ian would call them. A lot of these, there's quite a high volume that comes into the office. So what are your thoughts on that?
Yeah, we get quite a lot of these in relation to staff and parents. In relation to staff, they would sometimes look for their notes or the interview notes after they have gone for promotion and they haven't been successful. They're obviously entitled to that because that's their personal data. So we should give that to them. But we would have to redact any of the documentation so that other people are protected. They wouldn't be entitled to anybody else's personal data, just their own. We also get asked for board of management minutes in relation to promotions and, you know, appointments. Again, they would only be entitled to their own personal data in relation to that. On the parent data requests, we get it a lot of the time in relation to guardians objecting, or one guardian looking for the personal data and the other guardian objecting. In these kind of situations, unless there's a court order in place, the guardian is entitled to the child's personal data. But this issue comes up a lot in relation to whether or not the child should be asked for their consent. We've had students who didn't want their junior cert results shared with their parent. That was seen as valid. They were allowed, refused to consent to it. Leaving cert results, we had a case where there was a case of discrimination because he said he wanted his child's leaving cert results and we refused because the student involved was alienated from her father and didn't want him getting them. So there is this debate that goes on about the age of consent. I would say that, you know, from first year onwards, really, if there's any kind of a conflict, you should ask the student. I think Liam had a case also. You might like to comment on it.
That's true, Catherine. I did. It was a very sensitive matter where the father of the student wanted to access the notes of the students, the notes that were taken by the guidance counsellor in relation to the student, and the student used point blank on the basis that it was her personal data, and the board on that basis refused to comply with the father's request, and even though he threatened all sorts of proceedings, legal proceedings and everything, he ultimately accepted the decision.
Yeah, and that's very much what we found, that, you know, if the student has an issue with it, we need to respect their wishes on it.
And Catherine, doesn't that feed very much into the data protection, this consultation paper that we mentioned earlier?
Absolutely.
Yeah, very good. Another issue I'd like you to talk about is the question of data transfer, and you've listed a number of organizations there. And also, when you're dealing with this, can I just make the point of schools sometimes being seen as a soft target for people looking for data, and dare I say solicitors phoning up the school, the principal, looking for details in relation to where there may be a family separation, etc. So what's your take on that?
Yeah, we get it all the time, you know, people just phoning up and saying, you know, I need, you know, documentation in relation to the students in the school, and, you know, or people calling to the school and asking for the information. There has to be a legal basis for it. So if there is a legal basis for it, I mean, the guards sometimes look for information. Schools are sharing data all the time with external agencies like NEPS, you know, NCSE, TUSLA. So there is a legal basis there, but we have to get it in writing and see why they're looking for the information, because otherwise we can't share that sensitive personal data.
Thanks for that, Catherine. And we move on now to the question of accountability. And Catherine mentioned the fact that the controller is the board of management, but with control comes accountability. So Ian, you've highlighted just a few areas that we should be aware of there.
Yeah, thanks, Dave.
Thanks.
You'll recall that the 7 principles that we looked at earlier on, one of which was accountability. And, you know, this list of questions really raises a couple of if you like, principles of data protection law. One is, that a data controller like a school should ensure that personal data retained by the school is limited to what is necessary for the purpose for which it's held, and that's that you have a lawful basis for retaining it. But there's another principle also, and that is that a data controller will hold, for example, a student's personal data for no longer than is necessary for the purpose for which it's held by the school. So that's a time thing. So, particularly in dispute situations, and also in DARs, when there's a data access request, some of these issues around accountability come up. Who do you hold data on? What data do you hold? Why do you hold it? That's the principle of lawful basis. Who do you share it with? What Catherine just spoke about. Do you still need it? That's the time part. And is it secure? And that's around the confidentiality thing. And we might talk about that again in a minute, but I just want to mention one thing around, security. There's an absolute obligation, obviously, on all data controllers, schools, to keep their data secure. One big hot topic in the whole world of data, personal data and data security is cyber attacks. And you'll all be familiar with reading about cyber attacks, cyber security, or whatever. And I just want to highlight one thing. I'd encourage all principals to do a check with their insurer as to whether you are insured in relation to a cyber attack in your school. And I am suggesting, because I know some schools have done this, that some schools may find that you don't have insurance to cover that. And all I'm simply just kind of advising you is that I'm certainly aware of one of the big broker firms, maybe more, who has arranged, if you like, a top-up insurance to cover a cyber attack. And it's just something to put on your to-do list, if you like.
Thank you, Ian, and we'll be back to you in a moment. I'm back to Catherine now in relation to technology use. And as we speak, Catherine, two of my family in post-primary are busy working upstairs, and I'm really grateful to the respective schools. And to Paul there, you'll be happy with this too. So, but Catherine, it does bring risks, and it's inevitable. We talked about oil flowing and that when we go online, there are risks. So would you like to take us through a few of your thoughts?
Yeah, and I'll add to that because I have a first year who's hopefully downstairs on Microsoft Teams and is getting great benefit out of her online classes. So very thankful to her teachers and her school in relation to that too. It's great. I think most schools at the moment are well up to speed on the general points here, but just to go down through them again to remind everyone, just to make sure that the staff are using the schools approved devices, networks, cloud sharing sites, and other apps. I know Microsoft Teams and Zoom, and there are quite a few apps, but I think Microsoft Teams seems to be the one most widely used. Have all staff upgraded their operating system and programs, and do they have antivirus in place? Very, very important. Most people should be doing this at this stage, but again, I want to emphasize that, because we have had issues on this, they need to use only their school email addresses. It's very important. And the board and the principal ensure that the systems it's using are secure. We've discussed that before. We have discussed the acceptable use policy, and most schools have updated those now to take into account the online teaching that is going on. And most importantly is to monitor it. There needs to be a monitoring of it.
And just to say, David, that we have in very recent days with a number of situations where outside parties external to the school have managed to gain access to, if you like, an online class So just vigilance is the word. Vigilance on the part of schools and teachers is important. Some of that.
And I think at the beginning of it all, the systems that people were using didn't, you didn't have passwords. They weren't as secure as they are now. So hopefully that situation is only a rare situation, and most of the time something like that wouldn't occur. But it shows that you have to be very vigilant and have the proper systems in place.
And thank you, Ian. Back to you, Catherine. Speaking of vulnerability and that, emails, we're lashing them in and out.
Yeah. And the one thing I would say is that, everybody makes mistakes, and we get queries in all the time. The amount of emails that are going back and forth, it's inevitable sometimes that, something will happen. And people ring us and they say, I can't believe I did that. But I mean, you'll probably find that it has happened in the past and it will happen again. So, you're not alone in it. What is very, very important, and we've discussed it already, is to notify the Data Protection Commissioner straight away. Only in the last week, I've had a query in from a principal. They attached a student's IEP by mistake to a number of parents. But, as we've advised, she got on to the Data Protection Commissioner. The people involved were asked to delete the email straight away. So the Data Protection Commissioner felt that the proper steps had been taken, and that they weren't going to investigate it any further. I had another case recently where instead of using the BCC, the CC was used. A parent got access to all of the email addresses of the other parents in the school and the staff. And it only came to light when she emailed a letter of complaint attaching on various documents to everyone in the school, including the staff, all parents. So I asked the question, well, how did she get it? And when the principal went back and looked, she realized she had made a mistake, and sent that out to her previously. So again, we notified the Data Protection Commissioner and we're waiting for advice on that.
And again, reinforces the point that Ian and Lee made earlier, is you put your hands up if there's a breach, report it, deal with it. Thanks very much for that, Catherine. And I'm going to go back to Ian there in relation to the whole question of storage and particularly retention. And you have two interesting pictures there, one of boxed files, like it looks like a warehouse, and the other is of a magpie. So explain, Ian.
Thanks, David. Well, I mean, the first thing to say about the top picture is I say in jest, we hope that your storage room, your data storage room in your school doesn't look like something like that. The magpie is up there because by repute, magpies are wont to collect other people's property, particularly anything shiny. You'll heard stories of magpies' nests which have found, and the people find all sorts of things, glistening, jewelry, all sorts of things in it. So you don't want to be a random collector of other people's property or other people's data. We've put in a big list of stuff there that schools might retain, collect, data might collect. And really, we're putting it up there in a provocative way to make you focus as principals on your data retention. And you really should have a policy on retention of data, because if you get a complaint from a parent, for example, or from a member of staff, or you get an access request, it may be followed up with a complaint that why are you retaining? Why do you still have such and such records, for example? Now, we understand that certain records need to be kept indefinitely. For example, the attendance, the enrollment, if you like, of a student in your school is something that is really kept indefinitely. There are other records that you need to retain. There's a statutory basis for you retaining certain data. But each of those bullet points will have perhaps a different approach in relation to data retention. And I know this is a big job, but we would really be encouraging every school to do a kind of an audit of your data and look at your retention schedule attached to it. And just as regards a retention schedule, we're just putting up a link there to, if you like, you'll find a kind of a suggested draft retention schedule. I think this was prepared, as far as I know, by the JMB, and has kind of been, you know, adopted, if you like, by other groups that we've put up there. But it's not that retention schedule is just a suggestion. It is not blessed, if you like, by the DPC, because the DPC has said they don't see it as their job to give a blessing to data controllers, individual data controllers, retention schedules. But we really would encourage you to look at that and discuss it and adjust it or adopt it or whatever it is, but have a data retention schedule, because then you're not going to be making decisions on an ad hoc basis. And the other thing you need to do is, you know, this data retention schedule should be cross-referenced in your policy. But keep coming back to this, your policy, because in a dispute situation, if you can point to your policy, it is a huge benefit in showing that, you know, you're making decisions in an informed and structured way.
Thanks, Ian. I'll be back to you in a moment. I'm going to go over to Liam now. And Liam, the whole question of teacher notes. There was a traditional view that in relation to teacher notes, what we hold, but I'm afraid it's not that straightforward, Liam.
No, it's not, David. It can be quite complicated. If you go back to what we were saying earlier, that the data controller is the board of management, and what a data subject is entitled to is personal data held by the data controller. That's personal data held on the filing system, electronic or manual or whatever, of the board of management of the school. So, traditionally, teachers' notes were regarded as the property of the teacher, and that can still be the case in certain circumstances. But where we're asked to advise on this, the starting point for us is, why were the notes kept in the first instance? So if the teacher is taking these notes as part of her or his compliance with their professional duties and their professional role as teachers. So, for example, they're keeping notes in relation to a child with SEN, for example. Those notes are being taken in compliance with the teacher's professional role. And so if the teacher is going to rely on those notes in terms of either explaining her or his performance of that role, then I think they form part of the record, the personal data relating to the student concerned. Now, it's foreseeable that a teacher might take notes at home, which are not that aren't within the control of the school or whatever, and the school has no control over that, because it's not data which is held by the school. But I'll put it to you this way: if a decision is taken that a teacher's notes are purely personal to the teacher and do not form part of the personal data of the student, then the teacher cannot and will not be able to rely on those notes. In other words, you can't have it both ways. You can't say it's purely personal and not include them as part of the personal data of the data subject if a DAR is made to the school. Each case has to be looked at individually. There is that if you like, the overlap between the personal and what's held by the school as an institution on file in relation to the student. But those are the principles which inform our advice in relation to these kinds of issue.
Ian, thanks for that clarification, and it'll be much appreciated by our participants. Ian, you're going to attempt to pull a few threads together in relation to what we have done so over the next 2 slides as we're coming to the end.
Yeah, thanks, David. I'll do my best. I mean, these are just kind of things that we as a team have put together in terms of what we've learned from our clients' experience. The first thing is, I mean, obviously, you know, there's a 1-month time limit to respond to a data access request. And I put up there, get started quickly, don't put it off. Because too many schools come to us when they're when the 1-month time limit has either half gone or 3/4 gone. You know, you need to get started on day one. First thing to do is collect the data, because that takes time. You know, what data do you hold? There is a facility in the Data Protection Act and the GDPR that if you have a particular reason why you're not going, a valid reason why you're not going to be able to meet the 1-month time limit, there is a facility, provided you do it early doors, as they say, to go back to the requester and say, I'm going to need more time. Catherine spoke about, you know, is separate consent required of the student? But this arises in particular in a dispute situation where you have 2 parents or 2 guardians, you know, in disagreement. Not only then, but that's where the rubber hits the road enough, usually. Vital thing just there, keep a copy of the document sent to a data subject in response to a DAR, because if there's a subsequent dispute about the adequacy of the documentation you've given or the amount of redaction or something, if you don't have an exact copy, photocopy or soft copy or whatever it is of what you've given, you're really in trouble. Should a request be in writing? Well, strictly speaking, no. So strictly speaking, a 1-month time limit can start to run from a verbal request. We would always, as a matter of course, say to a school, if you get a verbal request it to be confirmed in writing, because it's only then that the scope of the request is clear if there's any issue about the scope of the request. And the last thing there, and I don't want to repeat this, but, you know, retention of records. You know the principle, I spoke about it already there, but you should have, you should have a retention schedule, and you should address that and look and decide. And I often say, like, there's a lot of records that are just relating to a specific school year that there's no need for them to cover to be held after the school year. And in relation to those records, as a year leaves the school after 6th year, you know, and a new year comes in, you might be destroying that element of the data for 1 year and creating a new year. So you're not generating, a whole indefinite amount of data for years past. And just some comments in relation to protecting personal data. Great to hear from Paul there earlier on about the high percentage of principals in relation to satisfaction with their policy. But policies are not enshrined in stone forever. You need to be reviewing them, updating them, particularly around data retention. The world is changing all the time. And there's no point in having a fantastic policy if your staff are not engaged with it. So you need to be having the kind of discussions that we've been having on this webinar with your staff, because you're relying on them to comply with data protection law. Obviously, protocols around storage, safety, security, all the stuff that Catherine spoke about, they're all things that you need to be careful about, particularly with remote teaching, but particularly with remote teaching. David.
Thank you, Ian. I'm going to leave the last word, as it were, to Paul Byrne. Paul, over to you.
Thanks very much. I found this to be an absolutely brilliant webinar. Apart from the data which we were gathering in the survey, we were also taking questions. And I think every one of the questions which were put at the end of those surveys have been answered. I suppose I took down a few takeaways from the webinar. And I think one of the big things is that data compliance or GDPR compliance, it's a staff or a whole school commitment. And that needs to be communicated to the staff, as well as making them aware of the school's policy on data collection, retention, storage, and also what to do if there's a data breach. In the case of it's, as David says, hands up, not cover up, and do it very quickly and deal with it. Look, I'd like to thank the Mason Hayes and Curran team for this webinar and for the previous webinars as well, because all 10 of them are a huge resource which school leaders can draw on when they need. And the other thing is, if in doubt, I think always seek advice before you act. But thanks very much. It's always a pleasure to work with you. And the feedback coming from those who are attending the webinars is excellent as well. Well done on a job well done. And thanks very much.
Thank you, Paul, and equally for your help and that of NAPD in relation to running these webinars. I'd also like to thank our team, Liam, Ian and Catherine. They have a wealth of experience, many years between them. I think they're the three most experienced education lawyers in the country. So thank you for sharing your expertise and knowledge. In relation to data protection, we also have a data privacy and protection, a dedicated section that advise global firms like Twitter and Facebook. And fortunately, we can tap into their expertise too when we need to. In relation to the 10 webinars that Ian referenced, just to say you can access them very simply by going on to the Mason Hayes and Curran website and going into the education law section there, and you'll get them. But equally, to their credit, NAPD sent out a bulletin last month with a digital connection to all, it was 9 webinars at that stage, and it's also referenced in the Leader magazine. So you have 2 different sources. But to you, the participants, we'd like to sincerely thank you for attending, and we hope that you have found some of the information useful and that you can go and tweak your policy if necessary. We'd also like to thank you, and I know it's personal to Catherine and myself, for the work the schools are doing online to support the teaching and learning. We're extremely grateful for that. And we want to wish you well in the weeks ahead. Ian will be in touch with you. He's going to send you an email with the recording of this latest webinar. So thank you very much and goodbye.